Court calls the case, People versus Jarrell Sewell.
Good morning, Your Honor. Amy Reiser on behalf of the people.
Good morning, Your Honor. Tina Saxon on behalf of Mr. Sewell.
Your name? Jarrell Sewell. Thank you.
Your Honor, we'd like to make a request for a bond modification and ask for a preliminary exam date,
Is all discovery complete?
to my knowledge.
Yes, Your Honor, it should be.
Would the people have their witnesses available to 6?
August 6th, yes.
Yes.
Well, I have to
Your
find the
Honor.
minor child that was the subject of the child abuse. They're at the same address. Obviously, the defendant's not there, but yes, we will.
Okay.
And I would indicate that in my review of the file today, I will speak with the deputies. There will be a resisting and obstructing charge added at the time of exam.
Okay. What were you going to say, Ms. Saxon?
Can we have the preliminary set for the afternoon of the 6th?
You can work that out with the judge I assign it to. I get 9 a.m. And you'll be expected to be here at 9 a.m. because they're going to have to work that out and coordinate that with the jail also. So,
Well, I have to be in Oakland County for a preliminary in the morning, so.
well, they may wait. Who knows? I
Okay,
can't help you. I can't help you with it.
I understand.
All right. As to bond.
Your Honor, I'm asking for a reduction from the $10,000 cash bond to a PR bond with tether.
Any response from the people?
Your Honor, we would ask that that be denied and the bond remains set as it is until the time of preliminary exam. The police were called to the scene because the defendant was assaulting a minor child, so much so that another adult at the scene tried to get him off the minor child by grabbing the defendant's testicles, which created a fight between the two of those. Deputies arrived on scene and there were multiple resisting and obstructing charges involving the defendant and other individuals at the scene. So I think he's a danger to the community and to the minor child in this case.
The police
don't know.
report doesn't support that statement.
Pardon?
The police report doesn't support that statement. The child has a laceration to her finger. And it was his sister that was in a mutual combatant situation. And he was attacked, grabbed by his testicle. In that altercation, his sister is an adult.
Motion for bond reduction is denied. Bond will continue. You can raise it at the time after the preliminary examination.
Juan Brown, Deputy Chief Public Griffin on behalf of Ms. Griffin. State your name for the record.
I'm Sharonda Griffin.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We believe that this is something we can work out through a universal plea agreement. However, we will need time to work out the details. There's something she has 14B that has a next court date of July 22nd. So
On 14B matter.
yes. And so once that matter is resolved, we believe that we can resolve this very easily.
So why don't I put this to the 25th then?
So, yes.
Will that make sense? The 25th?
Absolutely.
Probable cause conference in these matters will be adjourned July 25th, 2024, 9 a.m. Bond continue.
Now, just briefly on bond, very briefly.
Yes, go ahead.
She does need to be able to take care. She's the caretaker for her brother. He has a traumatic brain injury.
Yeah.
I'm sorry, fiance. And she is the one who basically is his caretaker. He's missing his appointments now. She'd like to be allowed to have a bond so that she continue to help take care of her caretaker.
Well, I think I'd like to give her a bond too, but when I look at the offenses, I have no way of monitoring her or her conditions because I've got tampering with the electronic monitoring devices when we let her out. So I don't need a response from the people. Motion for bond reduction or any changes denied. Brighton, is it Brighton Warren?
Morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Mr. Warren today. Mr. Warren, can you state your name for the court, please?
Brent Warren. All right, what are we doing?
Your Honor, at this time, I do have all discovery. I am requesting a preliminary examination, and at the appropriate time, I'd like to address.
People would have their witnesses available the 30th. Preliminary examination will be set April 30th, 2024, 9 a.m. in person before Judge Barr. As the bond.
Your Honor, the bond is currently set at $250,000 cash or surety. The most significant charge is assault with intent to commit great bodily harm, murder. The allegations in that are that the alleged victim threw a bottle at Mr. Warren. He grabbed her hair and she put her to the ground, and as she did, she hurt her wrist. He does have a criminal history, but he is a lifelong resident of Ypsilanti. Resides now with his mother since him and the alleged victim have split up. He's employed, does DoorDash and Uber. He does also have a child, which is the alleged victim in this case in the area, who he's been seeing and trying to support. And he also has a support of I believe that $250,000 is an excessive amount of bond. I would actually request the court to lower the bond at a condition of a GPS tether, and we could certainly geofence him away from this alleged victim's residence and work.
Response.
Judge, the defendant was recently released from parole, serving a sentence for manslaughter. He was on camera in this offense, damaging the security system. He actually broke it. He tried to remove the door camera from her house. He punched it several times, removed it. He broke the victim's wrist in the incident that defense counsel is talking about, where he pulled her to the ground by her hair. Her wrist was broken. She finally made a police report to the police when he damaged her tires and slashed her tires, and that's when police were involved. I have serious concerns from victim safety. The police officers had serious concerns. They actually called me on the weekend on this case, extremely concerned about the victim and the stalking behavior of the defendant, that he just wouldn't leave her alone. I believe bond is reasonably set. He actually asked for a $500,000 bond at the time of arraignment. So I'd ask you not to change the bond. Thank you.
Anything else?
Your Honor, the allegations that rise to the stalking are alleged to have occurred over a long period of time. These charges miraculously appeared after Mr. Warren addressed the fact that the complainant had taken his tax refund check. The day after that happened, we get a slashed tires and a call to the police. So I know that Mr. Warren has no interest in being around her. He certainly denies all the charges, by the way, including the assault. But I'm just going based on what her allegations. This is something that the most serious allegation is the GBH, and that incident, which I don't even know when it happened. It's not in the report, was triggered by the alleged complainant. I believe that a lower bond with a GPS tether is adequate to protect.
Did he just get off of federal parole?
No, state parole, Your Honor.
State parole?
Yes,
So he was just released from parole. When was he released from parole?
July of 2023, I believe, right?
When I was released,
Parole violations.
no parole violations.
He served 7 years
They
and 2
haven't
months on a manslaughter and had no parole violations while released on parole.
Right, I understand that, but then within this behavior, at least according to the allegations, begins within 4 months of the time that he's released from parole.
That's when the allegations arose.
Right.
I certainly have a different view of what these allegations are.
All right. Well, everybody can sort that out then maybe on the 30th, but Motion for bond reduction is denied. Bond. Thank you.
On behalf of the people.
Good morning. For the record, Julian appearing on behalf of Anton Casey.
Thank you.
We are digging into patrol video for one of these cases. It appears that it might have been assigned under a wrong other file number, and I believe the people are really trying to locate where it might be. So we are asking for an adjournment of both, and then if we may address bond.
Master Bond, go ahead.
Yes, Your Honor. So there was, quite frankly, a very big misunderstanding even by counsel. And so Mr. Brooks was originally given PR bonds in these two matters. But however, he was not released. He was being held without bond on a VOP stemming out of these matters with Judge Conlon. And so he stayed with the PR bonds here, but stayed in custody until I was able to get him a release to home confinement tether from Judge Conlon. That's the day that he was released. However, unfortunately, and I confirmed this with Agent Heath yesterday, I was not aware that there was originally testing orders associated with these, and Mr. Brooks was not given any paperwork when he left the jail. I asked Agent Heath yesterday personally, was he given anything? He's like, I didn't give him anything. It didn't smack me in the face to go back to make sure that there was a testing order. He has been 100% compliant with home confinement. He has only left his residence 2 times for court, which was here before Your Honor, 1 for a misdemeanor and then 1 for the last PCC. So I learned.
Was he in jail right after February 1?
He stayed in jail until his release
On March 1st.
Yeah. Yes, Your Honor. And I would have arranged for everybody to be on the same page because his GPS tether is with Agent Heath. That's with Circuit Court. It's not with Community Corrections. So there was and Community Corrections obviously didn't know that he was on a home confinement tether. So Your Honor, what we're asking for, as soon as I learned about this on Friday when it was emailed to me, and obviously there were a lot of emails that went back and forth. I tried to clear this up with the court over, by the morning. I had Mr. Brooks turn himself in on Friday to the jail, and he's more than happy to go to Community Corrections. Agent, he said, hey, I'm more than happy to give him out time. Didn't know that he was, supposed to be doing that or have that. So it really it was not willful or intentional. And so we're just asking for a referral to Community Corrections.
So he didn't get a testing order on either one of these cases, you're saying?
I don't believe that he received any copies of anything when he left the jail. I asked Agent Heath, which is why I figured that Your Honor would be skeptical. But
What'd you say?
I said
That I'm skeptical?
that you might be.
Because he would have been told to test at the arraignment.
That's what I'm saying, Your Honor. We were so focused on the having him released, period. It did not smack his brain. It did not smack my brain to go back and double check. This really was not a willful or intentional disregard of Community Corrections. He's more than happy to go. And so we're asking for his release so that he can be released and go straight to Community Corrections, comply with that part of Your Honor's orders. And then
Any response from the people?
Nothing on behalf of the people.
I'm going to need 2 new orders on this. Bond will be reset at $5,000. Personal recognizance on each case. Defendant is to test at Community Corrections the previous conditions of his release remain in effect or reinstated.
thank you very much. Yeah.